Good afternoon, everyone, and welcome to today's Employment Law Lunch and Learn presented by Kelleher and Holland. Today we have two hot topics to cover in honor of Taco Tuesday. We will be covering the Illinois Biometric Information Privacy Act and what it means for your business, as well as the One Big Beautiful Bill Act's implications for employment matters. We encourage you to ask any questions using the Q&A button in the Zoom control panel. And depending on time, we'll try to answer them live at the end of the presentation, or we'll follow up with you via email directly. So we are serving up some sizzling insights with two of our seasoned favorites, Maura Ann McBreen and Madeline Kelleher from our employment law group. And adding some extra spice to the conversation, we've got a special guest from our litigation kitchen, Kate Rosendale. So let's start with the Biometric Information Privacy Act, or BIPA. Kate, can you start us off by telling us what this act is all about?
Yeah, so BIPA was enacted in Illinois in 2008, becoming the first major biometric privacy law in the United States. BIPA has been a landmark piece of legislation in protecting individuals' biometric data. So this includes things like fingerprints, facial recognition data, and other unique biological identifiers. Generally, it requires private companies to publicly post a general notice about the company's biometric data retention periods. It requires private companies to specifically notify and obtain written consent releases from persons before collecting that biometric identifiers and information, and it bans private companies from selling or trading the personal biometric data for profit.
And what constitutes biometric data as defined in the Illinois Biometric Information Privacy Act?
So, under the Illinois Biometric Information Privacy Act, biometric identifiers include a retina or iris scan, fingerprint, voice print, scan of a hand or face geometry, etc. Biometric data does not include things like writing samples, photographs, physical descriptions, etc. Biometric information is defined under the Act as any information, regardless of how it is captured, converted, stored, or shared based on an individual's biometric identifier used to identify an individual. For example, facial recognition would be considered a biometric identifier, and any information derived from that is used to identify an individual would be considered biometric information. And even though they say photographs aren't biometric information in some areas of the law, this is still up for debate and up for grabs. So be careful when taking photos of your employees to identify them.
Okay. And what is the effect of the recent amendment to this act, Kate?
So the Illinois BIPA was recently amended to limit potential damages and allow electronic signatures to be included in this definition of written release. So prior to the amendment, anyone aggrieved by a violation of BIPA to bring suit seeking damages of either $1,000 per violation for negligent violations or $5,000 per violation for intentional or reckless violations. With each scan, fingerprint, or voice print, it would become this separate actionable violation. And as you can imagine, this has posed significant challenges for some businesses, leading to this wave of litigation over alleged noncompliance and payments of thousands in damages per plaintiff. Now, however, employees who allege BIPA violations can only recover once, regardless of how many times their biometric identifiers were utilized. Further, an individual aggrieved by a violation of BIPA may now only recover one time for such violations if the private company used the same method of collection for each violation. Summing up the two sentences, an individual aggrieved by a violation of BIPA may recover for each violation in which a private company uses a different method of collection.
And how can employers handle this employee and consumer biometric data responsibly?
There are specific guidelines every employer should follow if they collect biometric information and data from their consumers and/or employees. So the first thing is develop a written policy. This written policy should be made available to the public and establish a retention schedule and guidelines for permanently destroying employees and consumers' biometric data. when that initial purpose for collecting it has been satisfied within 3 years of the individual's last interaction with the private entity, so whichever occurs first. Employers should work with counsel to ensure their effectiveness and accuracy of any policy covering the collection of that biometric data or information. Additionally, inform your employees and obtain a written release. Private entities are required to do 3 things if they collect, capture, purchase, receive through trade, or otherwise obtain this biometric data. They must inform the individual in writing that their biometric identifier or information is being collected or stored. They must inform the individual in writing of the specific purpose and how long they'll be collecting, storing, using that biometric information. And they must receive a written release from the individual. So this is where that amendment comes in. A written release now includes that electronic signature. It's included in the definition of a written release, as well as informed consent. And in the context of employment, a release executed by an employee as a condition of employment. And then refrain from selling, leasing, trading, or profiting from an individual's biometric data. And lastly, be mindful of disclosing, redisclosing, or disseminating biometric data. There are instances in which a private entity may disseminate biometric data, and that's if the disclosure completes a financial transaction requested or authorized by the individual, if the disclosure or redisclosure is required by state law, federal law, or municipal ordinance, or the disclosure is required pursuant to a valid warrant or subpoena issued by a court of competent jurisdiction. If none of these circumstances apply, the private entity must obtain consent from the individual to disclose or redisclose that information or data.
All right, great. So, Madeline, what's next regarding this technology?
So, laws surrounding biometric data are becoming increasingly popular. States like, obviously, Illinois, Texas, Washington, California, and Illinois, or in Arkansas, have all enacted some form of a Biometric Privacy Act. We can most definitely expect to see other states starting to do the same, as biometric privacy is becoming an ongoing concern. For example, New York right now is highly considering and enacting a biometric act, privacy act.
And what should employers do now that they're aware of these kinds of changes?
Private businesses that collect individuals' biometric identifiers or biometric information, they need to be proactive in understanding and complying with BIPA requirements. It's important to work with employment counsel to make sure these policies and procedures are updated in accordance with biometric information and applicable laws.
All right, thank you for that. Let us spice things up a little bit, and we're going to fold in a new layer to our discussion, the One Big Beautiful Bill Act. It's hot off the legislative grill as of July 4th, 2025. And while this dish has something for everyone, from taxpayers and families to investors and healthcare recipients, we're going to dig into the ingredients that matter most to employers today. So, Madeline, start us off on the OBBBA and tell us what the act did change that employees and employers should know about.
Sure. So overall, there are a few provisions in the One Big Beautiful Bill Act that will directly impact the employment sector, including changes regarding health policies, overtime pay and tips tax treatment, welfare policies, bicycle commuting, executive compensation, and a few other miscellaneous employment-related changes. We will go over each of these areas during this presentation.
So, Maura Ann, let's fold you into this conversation. Tell us a little bit about what health policy changes were made in the One Big Beautiful Bill Act.
There are 3 major changes to health policies. The first one is the extension of a recently expired safe harbor provision that was adopted during the COVID-19 pandemic, allowing employers to offer telehealth services on a pre-deductible basis for employees enrolled in high-deductible health plans without disqualifying HSA eligibility. That was the key part of this, that it doesn't disqualify HSA eligibility. So it offers greater flexibility and potentially lower healthcare costs for employees. The change is applied retroactively for plan years beginning on or after January 1, 2025. Second, there's an expansion of the bronze and catastrophic level health insurance. Effective January 1, 2026, all bronze and catastrophic level health insurance plans, which are options under the Affordable Care Act that are available on the individual market, will be treated as high deductible health plans, even if those plan options would not otherwise meet the standard high deductible health plan requirements. Third, there's direct primary care coverage and HSA eligibility. The Act makes direct primary care service arrangements which provide access to certain primary care services for a fixed monthly fee compatible with HSA participation. Effective January 1, 2026, the direct primary care arrangements will not be considered disqualifying coverage for purposes of HSA eligibility, so long as the membership fee does not exceed $150 per month for an individual or $300 per month for a family, indexed for inflation, effective 1/1/2026. The Act also clarifies that direct primary care fees within those limits are considered qualified medical expenses that are eligible for reimbursement from an HSA or can be paid tax-free from HSAs so long as they do not cover general anesthesia, prescription drugs other than vaccines, nor lab services not typically administered in an ambulatory primary care setting.
All right, great.
Okay. All right, next.
Madeline, what did the Act change with regard to overtime pay and tips that Maura Ann just mentioned?
Yeah. So the bill introduces a federal income tax deduction for both qualified overtime and qualified tips. This is all retroactive, effective beginning January 1st, 2025 through December 31st, 2028. So there is an end date here. This deduction is available regardless of whether an individual itemizes or takes the standard deduction, with a phase out for higher earners beginning when an individual's modified adjusted gross income exceeds $150,000 for the year, or $300,000 for married couples filing jointly. The deduction applies only to federal income taxes, so individuals and employers remain responsible for deducting and paying applicable Medicare and Social Security taxes with respect to qualified tips and overtime as such are taxed on at the state level. Overtime eligible for the deduction is limited to $12,500 or $25,000 for married couples filing jointly. Qualified overtime compensation means overtime required to be paid under Section 7 of the Federal Fair Labor Standards Act, FLSA. So overtime not required by the FLSA, such as potentially more generous overtime required under state laws, a collective bargaining agreement, or paid voluntarily by employers, is not eligible to be deducted. Additionally, only the premium portion of overtime can be deducted. For example, if an individual is paid $10 per hour for non-overtime earnings and $15 per hour for overtime, only the $5 per hour premium pay for overtime is eligible for the new tax deduction. The tips that are eligible for the deduction are limited to $25,000. Qualified tips means cash tips received by an individual in an occupation which customarily and regularly receive tips on or before December 31st, 2024. So the Act requires the Treasury Secretary to release a list of qualifying occupations within 90 days of the enactment. So that should be coming up around, maybe a month or so. Workers in certain specified businesses are not eligible for the tips deduction. Specified businesses include, for example, those providing services in accounting, health, law, actuarial science, athletics, brokerage services, consulting, financial services, or the performing arts. Cash tips, for purposes of this act, include tips received from customers that are paid in cash or charged, and in the case of an employee, tips received under any tip sharing arrangement. This amount has to be paid and determined voluntarily by the payer without any consequence in the event of non-payment and can't be subject of negotiation. So it would exclude, for example, mandatory service charges and mandatory gratuities. The Treasury Secretary is authorized to establish other requirements to qualify for the deduction as well.
All right, so Maura Ann, what welfare-related changes were made in the Act?
All right, so there are 4 major changes with regard to employee welfare benefit plans, and we're going to talk about each of those. So first of all, they've increased the dependent care limits. Starting with plan years on or after January 1, 2026, the annual limit for a dependent care account, which is called a DCAP, increases from 5,000 to 7,500, and for married couples filing separately from 2,500 to 3,750. That provides more tax relief for childcare and adoption assistance. Unfortunately, the limit will not be indexed for inflation in future years. Employers wishing to increase the dependent care of limits for 2026 should work with their third-party administrators and legal counsel to adopt necessary plan amendments, including updating partisan communications, as well as consider the impact of any amendment on passing the notoriously difficult to pass 55% average benefits test. Employees should also conduct periodic non-discrimination testing throughout 2026, which may be more difficult to pass with the higher contribution limits. And consider whether contributions should be limited for some participants. Then second, I want to talk about there's loan repayment assistance for students. So effective beginning January 1, 2026, employers are now permanently allowed to make student loan repayments of up to $5,250 for employees on a tax-free basis under qualified educational assistance programs under Section 127 of the Code, of which this amount will be indexed for inflation. So this amount is indexed. The 5,250 will be indexed. Third, there are Trump account benefits. Effective beginning January 1, 2026, a new type of tax-favored accounts for children, referred to as Trump accounts, can be established for children under the age of 18 with a contribution limit of up to $5,000 per child annually, of which this amount will be indexed for inflation. Investments in these accounts grow on a tax-deferred basis, and distributions are generally prohibited until the child attains age 18. These Trump accounts may also be available as an employee benefit, where employers may choose to contribute up to $2,500 per year, also indexed for inflation, to employees or their dependents tax-free. Employers who wish to offer this benefit will need to adopt a written plan document and comply with non-discrimination rules similar to those that apply to dependent FSAs. The Trump administration will also contribute $1,000 to the accounts of children born between 1/1/2025 and 12/31/2028, who are U.S. citizens and whose parents have Social Security numbers. Subsequent contributions may be allowed annually on a tax-deferred basis. It's not clear whether those contributions will occur, but the Trump administration will make them for the next 3 years. Fourth and finally, expansion of the employer-provided child care tax credit. The employer-provided child care credit currently provides businesses with a non-refundable tax credit of up to $150,000 per year on up to 25% of qualified child care expenses provided to employees. Therefore, an employer must spend at least $600,000 on child care related expenses to receive the full credit. Now, effective beginning January 1, 2026, the One Big Beautiful Bill Act greatly expands the employer-provided child care tax credits through first increasing the percentage of qualified child care expenses from 25% to 40% and up to 50% for eligible small businesses, and second, raising the maximum credit from $150,000 to $500,000 per year and up to $600,000 per year for eligible small businesses. Qualified expenses may include, for example, amounts incurred in constructing a child care facility or training child care employees. To claim the full amount, a business must spend at least $1.25 million on child care services. This maximum credit will be indexed for inflation following 2026. Additionally, the Act allows small businesses to pool their resources to provide child care to their employees and for businesses to use a third-party intermediary to facilitate child care services on the business's behalf.
And Madeline, what does the One Big Beautiful Bill Act provide with regard to bicycle commuting?
So, effective beginning 2018 and through 2025, the Tax Cuts and Jobs Act of 2017 had repealed the bicycle commuter benefit, which allowed employers to reimburse certain bicycle commuting expenses up to $20 a month tax-free. This benefit was supposed to return in 26. However, the One Big Beautiful Bill Act has permanently repealed this option. Nevertheless, employers may continue to provide bicycle commuting assistance on a taxable basis. This change will become effective beginning January 1st, 2026.
And more, Anne, what executive compensation changes were made in the OBBBA?
I will shorthand the three changes that were made. First, it helps pay the provisions will help pay for the other provisions of the act. So it's viewed that the exec comp provisions will change some of the other provisions, will fund them. Secondly, they will clarify the application of the deduction limits provided under Section 162M for compensation exceeding $1 million paid to certain executives of public companies as it relates to executives of companies that are part of a control group or affiliated service group. So in other words, that income will be pooled and then it will be aggregated and then the deduction will be prorated for those people. So that's a major change and it's meant to close a certain loophole that was perceived. Third, they will expand the application of the excise tax that currently applies to tax-exempt organizations with respect to the top 5 most highly compensated employees earning more than $1 million per year. The expansion makes this excise tax applicable to all current and former employees. So those receiving severance pay who had been retired years ago after December 31, 2016 will then be hauled back into this excise tax. So it's possible that somebody who retired in 2016 would be found to have more than $1 million in pay and then be hauled back for the excise tax. All right, so Marilyn, I'll turn it back over to you.
So, Madeline, what else did the One Big Beautiful Act change?
Yeah, there's a few additional miscellaneous employment-related changes. I'll go through a good few of them. First, the Act expands the SALT deduction. So the Act eliminates the state and local tax deduction, commonly known as a SALT deduction. So it eliminates this SALT deduction cap, which is currently set at $10,000 and $5,000 for married taxpayers filing separately. In general, income taxes paid or accrued in carrying on a trade or business or an income-producing activity are subject to the individual SALT cap. The SALT cap for individuals is now set to expire for taxable years beginning after December 31st of 2025. The bill also temporarily raises the federal cap on the SALT deduction from $10,000 to $40,000 starting in 2025 with inflation adjustments through 2029. However, if now extended, the cap will revert back to $10,000 in 2013. That's the federal cap because by that point in time, the state cap will be eliminated. For those with modified adjusted gross income above $500,000 in 2025, the cap on a taxpayer's deduction phases down, but won't drop below that $10,000. Second, the Act eliminates moving expense reimbursements and deductions. So the Act permanently eliminates the tax-free qualified moving expenses reimbursement for employees and the employer moving expense deduction for moving expenses, except for active duty members of the armed forces and members of the U.S. intelligence community. This change is effective for reimbursements from 2018 through 2025, unless the 2018 reimbursement could have been excluded by the employee if paid in 2017. So this is a retroactive effect. They're looking at reimbursements all the way back to 2018.
That one is interesting because I've had a number of executives who have asked for moving expense reimbursements. That is very popular to high pay people who are coming on board.
It is. You know, that reimbursement can still occur. It's just now not a tax-free expense or a deduction that an employer can take. Third, the Act expands the list of exemptions from the deductions for business meals provided to employees by an employer. Another one is fourth, the Act provides for paid FMLA tax credit extension. So the Act permanently extends the federal paid family and medical leave employer tax credit that was set to expire at the end of 2025. So this updates the old structure by also updates the old structure by making the credit permanent, right? So now it's not going away for FMLA tax, and it lowers the employment tenure requirement from 12 months to 6 months. So this really expands eligibility for employees to utilize FMLA benefits. Additionally, the Act clarifies that state or locally mandated paid leave now counts towards satisfying the eligibility requirements for the credit without impacting the amount of credit an employer may claim. So, for example, in Illinois, there's a required paid leave that all employers need to have. And we do have a webinar on that if you want to check it out. So that paid leave now, rather than not counting toward that 6 months or 12 months prior for FMLA leave that they have to work, it now does count towards the work. The bill further expands the program to allow employers to claim the credit for amounts paid as premiums for qualifying paid leave insurance policies. Another one is that the Act addresses heightened worksite immigration enforcement by increasing the budget of the Immigration and Customs Enforcement. The Act expands domestic R&D expenditures. Previously, for tax years beginning after December 31st, 2021, taxpayers were required to capitalize and amortize specific research and development costs over a 5-year period, or if you were foreign R&D, over 15 years. The Act now allows taxpayers to immediately deduct domestic research and development expenditures after December 31st, 2024. So we also have a little bit of a retroactive effect here. So research and development conducted outside the U.S. must continue to be capitalized and amortized over 15 years. Additionally, small business taxpayers with average annual gross receipts of $31 million or less will generally be permitted to apply the immediate expensing retroactively to taxable years beginning after December 31st, 2021. Taxpayers that made domestic research and development expenditures after December 31st, 2021 and before January 1st, 2025 are permitted to accelerate the remaining deductions for those expenditures over a 1-year or 2-year period. One final one is that the Act retroactively extends the Employee Retention Tax Credit Program for the third and fourth quarter, so Q3 and Q4 of 2021 claims that were filed after January 31st, 2024. So this effectively codifies for those Q3 and Q4 quarters the current IRS Employee Retention Tax Credit processing moratorium. All right. So while businesses are not eligible to claim any Q4 or Q3 21 claims after the filed after that date, so filed after January 31st, 2024, claims from those quarters that were filed before January 31st, 2024 will still be processed. Claims from prior quarters aren't affected by the Act. The new law also extends the statute of limitations for the IRS to assess the validity of the Q3 and Q4 2021 employee retention tax credit claims. The IRS now has 6 years, as opposed to 5 years, from the date of filing to assess and audit claims from these quarters. The statute of limitations for 2020 and the first and second quarters of 2021 remains unchanged and is 3 years.
So, Madeline, what should employers do now that they are aware of these changes?
So, for all the One Big Beautiful Act changes, in essence, this act aims to reshape the employment landscape by offering new tax incentives, expanding access to certain benefits, and potentially impacting access to healthcare. Employers should be ready to work with legal counsel to review their current policies and plans to ensure continuing compliance and to consider these new benefit options, especially as they consider their 2026 benefit offerings. Here at KH, we can certainly assist with any plan amendments or explanatory materials, especially with respect to the Trump accounts. Any employer with employees who might be eligible for the $1,000 tax benefit should adopt a written plan.
That was a lot of information, ladies. Thank you. And Kate, as our special guest, could you please wrap up this session like a burrito for us?
Whether if you're looking for help in amending your policies for compliance or preparing contracts for protection, it's important for employers to obtain guidance from Employment Counsel with regard to both the Illinois Biometric Privacy Act as well as the One Big Beautiful Bill Act. And a word to the wise, be proactive. Don't wait until liability is at your doorstep to act. Kelleher and Holland LLC is well positioned and ready to assist you in navigating the rules and requirements.
Thank you, Kate. Thank you, Maura Ann. Thank you, Madeline. And thank you, viewers, for joining us today. If you have any questions, please contact any of our speakers. I've listed their contact information on the slide here. They can give you further guidance. We are here to help you. And watch your inbox for future emails and our social media pages for posts on details of our next webinar. And thank you again for joining us today.
Mm-hmm.